Welcome everybody to Law 2579, Australian Government and Statutory Interpretation. My name is Lloyd England and I'm your lecturer here for this unit at RMIT, and I'm delighted to be here with you. Australian Government and Statutory Interpretation is all about the expression or management of power. And today we're going to look at topic 1, which is chapter 1 in the prescribed reading, overview of government under the Australian Constitution. Before we get started, I'd like to acknowledge the traditional custodians on the land upon which we meet. We're gathering virtually via this recording, and we will be in person in the tutorial on Tuesday and Thursday, but we're currently, I'd like to acknowledge the people of the Eastern and Western Kulin nations. We acknowledge that the lands on which we're conducting our business today remain unceded, and we respectfully acknowledge the First Nations people of the 5 Kulin nations, their ancestors and elders, past, present, and emerging. So, I hold a Bachelor of Laws with honours from the University of Leicester and a postgrad diploma in legal practice from the College of Law of England and Wales, Master of Intellectual Property Law from Monash, and most recently a postgrad certificate in tertiary education from VU. I've taught out at Monash since 2007, taught torts law, law to young doctors, training in the medicine and nursing health sciences faculty, law to non-lawyers. I built a MOOC called Law for Non-Lawyers on a FutureLab platform many years ago, and I really enjoy talking and thinking about the law. So legal methods, legal reasoning, legal research, all these things I've taught for many years. I taught out at VU for several years and a range of courses, mainly torts and torts at Monash and torts at the University of Melbourne. I'm also teaching here legal internship on both the undergrad LLB and the postgrad Juris Doctor program. My research interests are law student wellbeing and legal pedagogy, so how legal teaching impacts law student health and wellbeing. So I'm delighted to be here with you today. It's a picture of me and a infamous High Court judge. All right, so there are a couple of videos by colleague Adam Fletcher on Canvas. It's a nice overview, and then there are some other videos as well that we are going to ask you to look at. There's one on the Magna Carta, so probably the single most important legal document in the history of certainly Western legal systems. The Magna Carta, 1215, signed at Runnymede in the UK. This is where the barons wrestled power off of a power-hungry and quite unfair King John, who, for those of you who've watched any Robin Hood movies, he's the mean king who just raised taxes for his own interest. And what essentially happened with the Magna Carta is they wrestled power off the king, off the monarchy, and made King John sign the Magna Carta, which gave us some fundamental legal human freedoms and rights. So the right to have a fair trial and the right to that no one is above the law, not even the king, right? So it was a massive shift in power, and it's probably the birthplace of modern democracies. So there's a great video from the Australian Human Rights Commission that will talk to you about why the barons in 13th century England wrestling power off a monarch impacts us today in terms of our current rights, and by having even the government or the president not being above the law. And this introduces the notion of the rule of law, whereby power is vested in a set or a legal system rather than in an individual. The rule of man versus the rule of law is aptly explained in chapter 1 of the text, which is for today's class. So please do make sure you read chapter 1 of the Lisa Burton Crawford text that's assigned to this unit. So we're going to have a think about why we study government. What do we mean when we say public law, and the definition of those classifications? And lastly, this notion of statutory interpretation. Now, one of the preliminary readings for today was also by a former Chief Justice of the High Court, Robert French, who talks about statutory interpretation in a statutory universe. And that is because we have a system of common law, judge-made law, that coexists and lives alongside statutory law, which, as we'll learn, are enacted through parliaments and are the expression of parliament. And we'll learn that statutory law trumps common law or judge-made law, and rightly so in our democratic system. However, it does fall to the courts to give effect to the intention of Parliament through legislation by virtue of statutory interpretation. So what we'll see is a dance between the will of the government and the people through democratically elected parliamentarians, who then vote on bills, which then become acts of Parliament, which then need interpreting by you and I and lawyers. But if there's a dispute, it needs to go up to adjudication. And we'll see that statutory interpretation, the ability to give effect and interpret the words of the statute, are critical skills of any modern lawyer. As Robert French correctly said in his article, there's almost no area of law that's not governed nowadays by some statutory provisions. So the common law has been swamped by legislative intervention over the years, and former Chief Justice French gives a lovely list, funnily enough in the world of torts, about statutory amendments to common law torts over the years. And for us in Victoria, it's the Wrongs Act 1958, which principally amends the common law tort of negligence. And when you study torts, you will get very friendly. In fact, here it is, the Wrongs Act. Can't get that in focus. No, I can't. The computer's blurred it. But anyway, there it is. Can I get it on the screen? Not really. Anyway, it's the Wrongs Act 1958, and that's what will govern the tort of negligence if you were to bring a civil claim, a civil suit in the state of Victoria. And that's interesting, isn't it? Because torts is a private law between citizens, and yet we're going to need statutory interpretation skills in order to interpret the modern law of torts via that Wrongs Act. The Wrongs Act provisions sit not in their own universe, but in the common law environment. So the legislative provisions that amend the common law of torts are found in that statute, but they exist not in a vacuum, but in the pre-existing common law of the tort of negligence. So there's a necessary interplay. So even there, when you're interpreting a private law doctrine or trying to sue under it, you have to go back to public law principles, which is why public law is often taught with statutory interpretation. And we've got a slide about that later. Oh, well, there it is, dot point 3. Because of the proliferation of legislation into the common law, legal education over the last 20, 30, 40 years, but more recently, there's been a real push, certainly in Australia, and you ask any judge what they want more of from their young lawyers, it's better training in statutory interpretation. So most law schools now have a subject devoted to statutory interpretation, because regardless of whatever discipline or legal subject you're studying, you will need to know how to interpret statutory provisions and the rules surrounding those. So that's why we've linked it in this course to public law and statutory interpretation. And as the second bullet point says, it's also a precursor to more advanced studies in this degree of administrative law, which is a standalone subject, and constitutional law, again, a standalone course, I believe, called. So, key learnings, and we learn them here at an introductory level, and then you get to practice your statutory interpretation throughout your law degree or Juris Doctor as you go through different courses. So, let's dive straight in. Public law is the body of law that attempts to exert regulatory or restrictive power on public power. And by public power, we're talking about official power, so the state, the government. As citizens, we're private individuals. As legal entities, corporations, partnerships, sole traders, charities, for example, we're almost private actors. And then in any legal system, the big actor is the state. So public power is in the domain of the state, and we give over, there's some ideas from Rousseau about the social contract, that we give up some of our individual autonomy, our individual power, to a bigger body, the state, in return for protections. And if you think about it, excuse me, you want to join a club, you have to give over some rights, but then you're a member of the club and you get the benefits that befall you for being in that club. So we allow our government to make rules for us, and then in turn we agree to be governed by them. And we're going to look at democracies, and in our democratic system of government, we elect members or representatives of our communities, and they go to in this case, 2 houses of parliament, and represent the views of their local constituents. So it's representative of the will of the people, and if you don't like what they do, well, then you vote them out or you change your representative. So we give over some power, but we don't want to give over all power. We don't want to turn around tomorrow and find we're all locked up arbitrarily. What a nightmare, what a disaster. So there are some checks and balances and limits upon that power that we bestow on governments as safety checks to make sure that there's legitimacy and scrutiny and chances to check that power. And as we'll see later today, our separation of powers is one such tool that modern democracies and legal systems utilize to make sure that power is not all vested in one single source. Because as the old adage goes, absolute power corrupts absolutely, potentially. And history would point to that. So it's safer to spread your power out from the government, the executive and the judiciary, and have some checks and balances on that power as it's exercised. And as we'll learn, in Australia, the government can't, it's not unfettered, it can't do whatever it likes. And the High Court can challenge it on its authority and rule that what they've purported to do legally is unlawful and thus has no standing. So, notions of jurisprudence, juris law, are theories or legal philosophy around what is law. Is it a social construct, or is it a social and a moral construct? And all around the world, legal systems are often find their birthplaces out of religions and other expressions of morality or codes to live by, and then they are in turn codified, the 10 Commandments. And if you go back to the monarchy, King John, before Magna Carta, the royal rulers felt that they had a divine right of kings, that their power was somehow God-given and holy. So modern jurisprudence thinks about this in terms of two main schools of thought: legal positivism and natural law theory. And we're going to explore a bit of that today. So legal positivists feel that law is made of social constructs and social values, and natural law theorists think that the law is made of social facts and moral facts. And we'll explore that. So have a think just now, maybe pause the video and think, where do you sit on that spectrum? So you can have legal positivists and natural law theorists, and there's a spectrum there. Do you think laws should be moral, or are an expression of morals? Or do you think laws are just a set of rules, like a Monopoly board? You buy the board game, you open up the wrapper and you crack out the rules and you read the rules. Right, what are the rules of the game? Oh, look, you pass go, you get $200. That's just an arbitrary set of rules. If you think it's just a rules-based paradigm, then you're a legal positivist. But if you think, no, there are some natural, inherent something, rights, call them, then you're more of a natural lawyer. So maybe pause the recording and have a think about where you sit right now. Okay, welcome back after that thought experiment. Here's a concept map of public law. In law, many people try and define things into categories, and of course, it's not always easy because the famous lawyer's answer is, it depends. So here's a visual representation of your classic categories of private and public law. I think, over on the far right, property law is a classic private law domain, although it is worth noting that also governed by statute, as is the law of torts, which is tort is an ancient French word for twisted. Think contortion, and you've got it. So any wrongs or civil wrongs, the law of torts provides a remedy, so you can right the wrong, usually in the form of compensation to put you back in the position you would have been had the harm not occurred, but not always. So torts, again, is traditionally between private actors, but noting you can sue your government for negligence when you're trying to sue a statutory authority. So is that a private law or a public law? It's a classic private law domain, but as I mentioned earlier when I showed you the Wrongs Act, it's also heavily governed by statute law. Whereas there are some areas of law that are slam dunk public law, and you'd have to say the big two are administrative law and constitutional law. They are by themselves about the Constitution and about administrative rights and obligations and processes within the administration of government. Human rights and statutory construction or statutory interpretation, which we're looking at today, is how to interpret public law, i.e. Acts of Parliament provisions. Human rights are a concept that aren't necessarily protected in our Constitution, unlike other nations who have a Bill of Rights, whereby human rights are spelled out. I'm thinking in the US, for example, has a Bill of Rights, and that puts a limit and a cap on public authority. And we know, don't we, there's those rights of free speech and the infamously troublesome right to bear arms that the government of the day just butts up against, and their Supreme Court can uphold those human rights as they're specifically enunciated in the Bill of Rights, whereas not so in Australia. There's no Bill of Rights, and some would argue there should be as an explicit protection of certain rights of individuals that cannot be overridden by the government. Whereas we rely, in the Constitution, we rely on our government in protecting our human rights. And then up there is the criminal law as well, which is interesting because unlike in a private law domain, where in the law of torts we have a plaintiff suing a defendant, two individuals, in the criminal law system, it's an individual who's accused and the prosecution is brought on behalf of the state. So the other party in that criminal dispute or claim, which essentially is what it is, it's a claim by the state that you've broken the criminal law and you're pulled up in court and they have to prove that you did it. And if they did, well, then the state, as I said, is the other actor and has much stronger rights than an individual, can incarcerate you, can fine you, etc. So when you're dealing with the government or the state or any arms of the government, then that's the public law end or definition. Whereas private law, contract law is a classic private law between individuals. But again, and as the textbook rightly pointed out, nowadays a lot of public functions are quasi-privatized to private companies. Your water bill is the example Lisa uses in chapter 1, private prisons and the growth of those. So the state has decided to outsource some functions which traditionally would have been the remit of the government to administer, now is individually or been contracted out through private-public partnerships, PPEs, enterprises, public-private enterprise, and most recently Vic Roads has been, for example, in Victoria, has been leased for 40 years to Macquarie Bank and a consortium of superannuation funds to run it for 40 years. So increasingly governments are subbing out and subcontracting their functions. So are you dealing with a public or a private legal entity there? So it will be blurred, and hence this diagram is not final and complete. So look, the textbook does a great job of introduction to jurisprudence and tries to paint for us what is the rule of law. And essentially, there's this notion, it's quite hard to define, but there's a notion that it's not the rule of an individual, that there is this concept or construct called the law, and that is the seat of lawful authority. There's notions of thick rules of law and thin rules of law. Thin would be suggestions that you just need some basic criteria, and that's enough to establish the rule of law, and the rest can be added to as you go, whereas thick theories suggest no, they must have certain quantum of basic characteristics in order to qualify as the rule of law. So we've got a few slides to give an overview of some famous jurisprudential theorists in this field to try and give a little colour to this concept, because it is used rather widely and loosely. There's a video to watch for today's session on module 1 where, you know, politicians will often say, oh, this is contrary to the rule of law. What do you mean? You know, so it is bandied around a bit, but we've got some theorists here to try and unpack for you, and this echoes the theorists that you're walked through in the reading. So AGSI was a highly influential 19th century legal scholar based in Oxford in the UK, and if you will never really read about the rule of law without hearing AGSI name pop up, because obviously the concept existed before he coined the phrase, is the expression in your reading, but he's also known as the foremost authority. So he felt that Parliament is the supreme law-making authority, and there's a great quote that no one can make law other than Parliament, and no man can undo it. It's parliamentary supremacy is AGSI's famous gift, that Parliament is supreme and it's the ultimate decision maker. And that's right, if you think about it, you can't have ultimate rights of appeal forever. You'd never have any certainty. And one of the goals of a legal system is to provide certainty and predictability. You want stability. You want a set of rules that creates a status quo. That's one of the goals. So in order to do that, you need a Supreme Court or a High Court or a final arbiter. There has to be a final decision made, and Parliament is the supreme lawmaking authority. No man may be penalised. Obviously, this language is quite archaic, and nowadays you can gender neutralise all of these old expressions, but back in the day they did unfortunately use male genders. But anyway, no person may be penalised unless there is a breach of the law applied properly by the courts. So we're trying to get rid of random people disappearing in the middle of the night without a free trial, a fair trial, people not being told what they're accused of, etc. So you want this notion of, well, hang on, so Parliament's the top of the tree, they're the ultimate lawmaking authority. You can't punish people arbitrarily unless there's a proper breach of the law. Every person, including the king or the president or even everybody, from the lowest of the low to the highest of the high, we're all equal under the law. And that, interestingly, was a key tenet of the Magna Carta in 1215. So everyone's subject to the law. Currently, the previous president of the United States of America is undergoing impeachment for breaches of their criminal law. Individual rights under English constitutional arrangements are protected by the common law, which is the courts, which has been developed over many, many years of the courts deciding people's cases. So here the idea is that rights have been found by judicial decisions over the years, and that these rights are enshrined in court decisions in time. Lon Fuller was a 20th century American legal scholar, Harvard professor, famously wrote in the Harvard Law Review the case of the Spelunkian explorers, which is a great judgment or law review article on a hypothetical, and goes down as one of the greatest statutory interpretation or introduction to jurisprudential readings in the history of sort of modern law. So I'll pop a note in the on the Canvas page, and if you have a bit of time, maybe later on in this course, you could read the case of the Spelunkian explorers, and it's a hypothetical case around some explorers who are trapped in some caves and are stuck, and they're forced outside of normal reality, and they commit a crime, and then they're rescued. So are they governed, or should they be governed by the laws outside of the cave, or were they separate? And there's these judgments handed down with different jurisprudential lenses, some positivist, some natural. So it's a great exercise in judicial interpretation of the law, statutory interpretation. He had a famous debate in the 50s with H.L.A. Hart, who was an Oxford professor and a big father of modern legal positivism and soft positivism, and they had a to and fro in the legal journals based on their jurisprudential positions. So, famous debate. Now, in the text, you're asked, he gives a thought experiment of a hypothetical king, King Rex, and trying and struggling to write the rules and laws of his new kingdom from scratch. And he keeps bumping into these pitfalls. And from that, Lon Fuller is illuminating 8 facets that he felt need to be present in order for the rule of law to be illuminated, right? and to be able to stand up. So one, here's 8 ways to make a failed legal system. Deciding each case ad hoc, like in and of themselves. It's going to fall over because there's no certainty, there's no predictability. You can't avoid, we don't know how it's going to go. And early doctrines of equity were criticised for, well, your decision you were likely to get at the court was dependent on the length of the Chancellor's foot. It was that, how long's a piece of string? That's how good or predictable those early equitable decisions were. So ad hoc's not useful for the rule of law. Prescribing laws, but then failing to make them known to subjects. You have to tell people what the rules are in order for them to abide by them. That's why we have parking signs. You need to know what the rules are. Number 3, deciding the rules after the event. Well, that's a bit harsh. So that's not fair, is it? You park and then someone says, oh no, actually you can't park there. I thought, I didn't know that. Can't change it. So that's retrospectivity, this notion. And we'll learn later there's a common law presumption against retrospectivity of legislation because it's not fair, is it, to change the rules backwards. Prescribing incomprehensible laws. There's no point in having laws that are so complex you can't understand them. How is anyone going to read the sign or understand what the rules are? Number 5, a corollary point about making contradictory laws. You must not have guns versus, oh, you also must take a weapon. Well, which one is it? You can't have them both. It wouldn't make sense. So it wouldn't give rise to a rule of law system. If you change the law too often, how is anyone going to know? I mean, that talks to number 2, doesn't it? About advertising and making people aware. But if they keep changing and it's impossible to keep up to speed, well then, how's anyone going to comply? And then finally, having a good legal system and good law, but then don't follow your own guidelines and rules. So again, see number 1, you're back to an ad hoc implementation of a administration of justice. That's no good either. So there are some notions that Lon Fuller. So conversely, if all of those 8 principles are established and in place, then there's the basis of a system that is emblematic of the rule of law. Joseph Raz was an Israeli legal scholar who ended up out at Columbia. There's a photo there of the previous Prime Minister defending Christian Porter, the Attorney General, from allegations of improper conduct, and was using the rule of law almost as a slogan, and that was Joseph Raz's complaint around it's just been used by as a political slogan. Oh, the rule of law, to give legitimacy to political will. So he felt, let's be clear on this, that the rule of law is not necessarily good or bad. It's not to be confused with justice, human rights, respect, dignity. It's got nothing to do with that. It's about the legitimacy of the system. And he felt it boils down to 2 aspects. That people should be ruled by and obey the law, and that the law should be such that people can be guided by it, i.e. find out what it is and then act upon it. So you can sense a couple of those 8 from our previous slide interwoven there into Raz's conception of the rule of law, i.e. knowledge of it and comprehensibility. He then gives us 8 subconditions on how to achieve those 2 big principles. So it's, again, number 1, law that's generally prospective, moving forward with arrangements, not retrospective. Law that's open and clear, law that's relatively stable, open, clear and stable rules for making of the laws. We need to know if something's legitimate or not. Observation of natural justice rules in administering the law. Ooh, here's interesting, isn't it? So here's some natural law theory around natural justice. Now, you'll often have heard this in movies, or someone's complaining it's against natural justice. So these are notions of inherent right or wrong, value judgments, often linked, but not necessarily, but often linked to morals or values that, oh, that doesn't seem right. So being arrested and detained without a charge would feel like a breach of natural justice. So, but it's hard though, because if you have to play devil's advocate, if you're a critic, you could say, well, hang on, where are you getting that from? And all you'd be able to say is, well, I don't know, it just feels wrong. So you're a little bit on the back foot there, which is why natural lawyers often get bashed. Figuratively, obviously not literally, by legal positivists, jurisprudence philosophers. Go, oh, well, you're just making this up. And the natural lawyers go, well, yeah, but we're not, because, you shouldn't take another life. Yeah, I don't know, it just feels right not to murder. So, whereas a positivist would say, well, yeah, but, if you have a death penalty and it's been proven, then it's okay to murder. So, these natural theories, and even Raz has got here that there needs to be observation of natural justice, rules in administering the law. So that's due process, fairness, transparency, rights of appeal, scrutiny, external review, all these things that we feel any system should allow themselves, and if they don't, well, then that's a bit closed and not transparent, a bit opaque. So natural justice, think of that as a light. All right. Number 6, an independent judiciary with the power to review legal compliance of the other branches of government. This is important. This goes to the separation of powers, where you don't want to give all your power to the politicians or the government because they can do whatever they like. We need to have an independent judiciary that we can complain to if we feel the government's overstepped or acted unlawfully or is infringing our rights. We need a body to hold the government to account, and that's an independent judiciary. We need courts that are easily accessible by the public. This is a big issue, consistently reduced government funding to legal aid in this country and many other jurisdictions around the world. Some would argue, I've even heard Justice Kirby say that there's a 2-tier system in Australia. There's a Rolls-Royce system of justice. If you've got money and you can afford top barristers, off you go, you're into court. Whereas the rest of us who are not prepared to spend or have access to those sorts of litigation funds, they're thousands of dollars to run a case, thousands and thousands. That the really accessibility of justice, access to justice, it's not fair. And you and I may have access to a Holden Commodore justice system, whereas the rich get the Rolls-Royce version and access to the courts with barristers at $5,000–10,000 a day. So, be aware it's not easy to be a small citizen and have your legal rights upheld because you've got to pay for the privilege. And then finally, limited discretion for law enforcement agencies so they cannot pervert the law. You don't want to give too much power to your law enforcement agencies, police, etc., because then they may pervert the law. And we've all seen movies of bent cops and taking bribes and bribing officials, and there are many societies that struggle with corruption, deeply ingrained in their mechanisms. So that's Joseph Raz. Lord Bingham he was a leading law lord, Tom Bingham, and he wrote The Rule of Law in 2011. And he wanted, there was a big push in the UK for plain English, and he wanted the laws to be accessible to the people. So Lord Bingham wrote The Rule of Law, and it's less academic. I mean, if you've read Joseph Raz, you might need a coffee or two. It's quite thick legal jurisprudential text. It's quite academic. Whereas the rule of law is much more accessible, and there's a big push for public legal education. It shouldn't just be the lawyers who understand the law. Go back to Lon Fuller and Raz that it should be accessible. So he wrote that the rule of law needs 8 requirements. They seem to favour the number 8, don't they? Law must be accessible, intelligible, clear and predictable. We've got a few in there. Legal rights and liabilities usually to be determined by application of law, not discretion. We don't want too much discretion at the hands of those charged with the administration of it. We need a bit of certainty, remember? Laws of the land should apply equally to all. Well, that makes sense. Unless objective differences justify different regulation. What's that about? I think that's inserted for if you wish to make exceptions for equity reasons, whereby you feel the playing field's not level, so you might have positive discrimination. So, for example, by having a job identified for a certain class of individual based on gender or race, in order to try and level the playing field. So you positively discriminate as a positive policy decision rather than inherently discriminate due to bias. So aside from that, everything should be equal, is the idea. Ministers must exercise their powers reasonably and in good faith, and only for purposes intended by Parliament. I like that. That's interesting, isn't it? As in the UK, the Boris Johnson debacle and parties during COVID, and I like having a notion of exercising powers in good faith. I think that's important, that our politicians are held. They shouldn't have business interests in affairs that benefit from their political positioning and manoeuvring, should they really? It does seem like a conflict. So I like having a good faith clause for members of Parliament. The law must afford, number 5 now, adequate protection of fundamental human rights. That's interesting from Lord Bingham. Giving human rights a standpoint, a touchstone within his concept of a rule of law. That's great. Adjudicative procedures provided by the state must be fair, like how they adjudicate matters. Have got to be fair. Can't be random. It can't be one set of rules for you and then I go in next week and it's totally different for me. So procedures, that's procedural fairness, if you like, or justice. The state must comply with its obligations under international law as well as national law. So that's giving the rule of law another conceptual circle or sphere of influence of the international rule of law. So that's interesting as well, isn't it? That your legal system does not operate in a global vacuum. Your state-based or nation-based legal system operates within its international legal context. And we'll learn that the United Nations, after the Second World War, did a Declaration of Human Rights, and there's now over 200 signatories who've ratified those conventions into domestic law to give effect. So the majority of the world's micro legal systems connect and interact and abide by the macro legal system of international law. And you will study that further when you take that course of international law. But here, Lord Bingham's saying the state must comply with international legal obligations whilst giving effect to its national legal obligations. They must be congruent. T.R.S. Allen was another influential legal theorist based in Cambridge. He took a different approach. So Allen is an example of a thin rule of law proponent. He just states a couple of top-level indicia or indicators of his theory and then feels that that's enough definition. States can claim to have a rule of law as long as their people's freedom and liberty is secured in a way that is consistent with similar freedom with the rest of society, and freedom defined as autonomy or independence is guaranteed to be free from arbitrary interference. So the default is freedom, and then you curtail some rights rather than a default of, well, you've got nothing and we'll give you rights. T.R.S. Allen talks about legitimate interferences with freedom must be justifiable on the basis of a public good. So this notion of it has to be for the benefit of all. The rule of law is not external benchmark for good law, it's an inherent requirement. If a law falls short, it's no law at all. And that's quite theoretical, isn't it? To stand up and say, well, hang on, that's not a real law because it lacks the inherent requirement of the rule of law. But there it is, an influential theory. And again, chapter 1 does give you a little more detail on T.R.S. Allen's rule of law theory. So what have we got? Well, we've got no fixed definition. We've got a concept, and I think together we've explored it from some different angles, from different jurisprudential philosophers and theorists and law lords. So it's getting a bit more concrete, isn't it? You can sense that there are some key characteristics you can attribute to the rule of law, but in a nutshell, it's the rule of law as a thing rather than a law of an individual or a person. LBC says on page 14, the law can only truly rule when people believe that it ought to. What do you think she means there? I think, in my mind, that means if you join a club, you agree to abide by the rules, and they can police those rules, but you really need everyone in the club, on the whole, to agree to them. You know, it's inherent, the stability of that club and those rules. And if everyone was trying to bend all of those rules, it would fall apart quite quickly. You know, you'd need more police than citizens, wouldn't you? So, before we come to a little pause, have a think about which of these conceptions we've looked at. Fuller, Raz, Bingham, Dicey. We've got a few to think about. Which of these appeals most to you, do you think, and why? And then have a think about which conception is the prevailing one in Australia. All right, we'll carry on in part 2. Thanks, everybody.